Honorable Court is again in session. Please be seated.
Good morning. Welcome to the Utah Court of Appeals. We're going to call the case now of In re L.L.B, case number 202100942. Counsel who are here, please make your appearances for the record.
Freya Johnson appearing for the appellant, who's the father in this case.
Good morning, Ms. Johnson. Appreciate you being here. You're not on the briefs, but you're going to be making the argument today. That's my understanding. Is that right?
That's correct.
Okay. We have, for the last 5 or 10 minutes, been trying to figure out why that's the case, and apparently the appellee filed a waiver of oral argument that somehow didn't make it into our file. I have a copy of it right here. Were you aware of that, Ms. Johnson?
I was aware.
We were not aware.
I'm sorry, the court was not.
Until right now. And so it does not look like there will be any argument from the appellee. Had we known that, we may have rethought the whole do we even schedule this for oral argument issue. And so, but anyway, you're here, Ms. Johnson, and so we're going to go ahead and hear from you. In light of the appellee's oral argument waiver, we understand there won't be any argument from them, so no need for rebuttal time. We're going to just start the clock at 15 minutes and hear your argument and take it from there, okay? All right, thank you, Ms. Johnson.
So in this case involved the question about whether to terminate a non-custodial parent's parental rights in conjunction with a petition to adopt made by the new husband of the custodial parent, who is the mother in this case. And the district court ultimately found that father is presently fit and capable as a parent, but nonetheless proceeded to terminate father's parental rights. The court incorrectly did so because the termination of father's rights was not in the best interest of child or strictly necessary in this particular case.
Can you speak to whether the strictly necessary requirement applies here, given that this is an Adoption Act proceeding in the district court rather than a juvenile court proceeding under the Termination Act?
Yes, Your Honor. I will speak to that. I think that even if the strictly necessary requirement doesn't apply, there still was not evidence that it was in the best interests of child, so I'll speak to that in a moment. But as to the strictly necessary requirement, the Adoption Act provides that the rights of a parent may be terminated in conjunction with an adoption petition pursuant to the provisions of Title 80, Chapter 4, Termination and Restoration of Parental Rights. And it refers to whether proper grounds exist under this chapter, which is Chapter 4. The subsection dealing with grounds in Chapter 4 is 80, it's been renumbered from the older cases, but it's now 84-301, subsection 1. And in this subsection it says, subject to the protections and requirements of 84-104, and if the juvenile finds termination of parental rights from child's point of view is strictly necessary, the juvenile court may terminate all parental rights with respect to the parent if the court finds any one of the following, and then lists several considerations like abuse and neglect and unfitness.
So your point is the strictly necessary reference is in the grounds statute.
That's
and
correct.
Therefore, the reference in the Adoption Act to grounds incorporates the strictly necessary requirement.
That's correct, Your Honor. That's what the plain language of the two statutes support. That's also what the policy behind the statutes supports as well. The considerations referenced in the ground statute 301 subsection 1 references 84-104, and that discusses the legislative policy to preserve the rights of the natural parents, the interest that children have in being raised by their natural parents in most circumstances, and the constitutional rights that are at stake. And for the reasons discussed in the reply, if this court were to adopt mother and stepfather's position that the strictly necessary requirement didn't apply in the Adoption Act context, it would create due process and equal protection problems. Particularly on equal protection, I just want to note that a parent who's facing either a private or a public termination petition, either under the Parental Rights Act or the Termination of Parental Rights Act or under the Adoption Act, is similarly situated in that their rights will be terminated if they're found to be, one of the statutory grounds is met and if it's in the best interest of the child. But they would be treated differently if the strictly necessary requirement was only applied to those for whom termination is sought under the Parental Rights Act rather than the Adoption Act.
And aren't they already treated differently though? Because if you're proceeding not in a private petition as we are here today, but you're proceeding under a DCFS petition, then the parent in those circumstances has had the benefit of a variety of reunification services, reunification plans, support services provided by DCFS. And so the parent in a private petition has not had the benefit of all of that. And so they're actually, I don't know if disadvantaged is the right word, but they haven't had the benefit of those services because of the different nature of the proceeding. Right?
That's correct.
And so the acts do treat them differently in some respects already.
The acts do treat them differently in some respects. The procedure can be somewhat different depending on if it's a private or public petition to terminate, or if it's under the Adoption Act or the Parental Termination of Parental Rights Act. The Utah Supreme Court dealt with this difference in a decision called In Re Adoption of BH 2020 UT 64. And in that one, they particularly were considering whether the procedural requirements of the Adoption Act applied to termination proceedings brought in conjunction with an adoption petition. And they concluded that they did. And so in that particular case, there was a jurisdictional question having to do with whether the proceedings at issue were subject to the Uniform Child Custody Jurisdiction and Enforcement Act. And in that particular case, the Utah Supreme Court found that the procedures of the Adoption Act apply. But in paragraph 48 of the opinion, they said the same considerations apply whenever a termination is sought, whether or not it is in connection with an adoption. So this supports that the same substantive standard applies whether you're seeking termination or one statute or the other, even if there are different procedural statutes or considerations that come into play depending on how the petition comes before the court.
And let me get to what I think is your next point, which is that setting aside this issue of statutory interpretation and whether the strictly necessary carries over from one to another, your position is that the evidence in front of the court wasn't sufficient to support the finding of the best interest, that the termination was in the best interest of the child.
That's correct, Your Honor.
And as I looked at the district court's order, at the very end, there seemed to be three bases that the court relied on in making that best interest determination. Is that how you read the order as well, that those are the three findings that the conclusion's based on?
Yes, Your Honor. The court explicitly looked at three factors and then sort of generally discussed categorical reasoning that adoption was preferable for the child. And under the case law, that's insufficient for a best interest analysis. The best interest analysis is meant to be holistic and to include an analysis of the physical, intellectual, social, moral, and educational training and general welfare and happiness of the child. And whether in light of those considerations, it's in the child's best interest to terminate the relationship with the parent at issue or to allow that relationship to continue in some form.
And you raised this earlier, I think, in your opening statement about the finding that the father was a fit and proper parent at the time of the hearing. And I assume your argument is that basically means you could not find that it was in the best interest of the child. Is that how I read your argument there?
It may be possible for someone who's a fit parent, nonetheless, because of circumstances, it to be in the best interest of the child. But the evidence in this case did not support that it would be in the best interest of the child to terminate the relationship for a few reasons. So not only did the court find that the father was presently fit and capable as a parent, and he had worked to overcome his drug addiction, which had impaired his parenting ability and had been an underlying factor leading to the bases for the parent's mother and stepfather seeking termination. But father also cooperated with mother and supported and spoke well of mother and stepfather to child. He worked to show his care for child and desire to build a relationship. He didn't receive a response or support from mother in continuing to rebuild his relationship with the child once he'd rebuilt or rebuild or overcome his drug addiction. He also, the evidence, the record also shows he had a parental relationship with another child, a half-sister from another mother, who did facilitate the visits and support him in having contact and building a relationship with that child. So those factors support that can be a cooperative co-parent, that he is able to build a relationship with his child, and that he's currently fit and competent and capable to be a parent, even if his drug addictions in the past rendered him, supported grounds for termination. Under the best interest inquiry, that's specifically a present tense inquiry. So even if he had these problems in the past, the best interest inquiry is meant to be focused on his capacity at the time of the trial.
At that point, assuming hypothetically we were to agree with your position in this case and find some infirmity in the way the district court went about this, what's the remedy here? What would you like us to do? There's some discussion in the briefs about whether it's reversal or whether it's remand, and what does that look like in your mind? And I may have some follow-up questions.
Okay, 2 parts, and then I'll see if you have a follow-up. But we argue that the proper remedy is to remand because the petitioners did not meet their burden of proving by clear and convincing evidence that it was in the best interests of the child to terminate father's parental rights. There was a trial, all the evidence came before the court, the petitioners had the burden and did not meet the burden.
So I think you meant to say reverse. You just said remand.
I meant to say
Yeah,
reverse.
I was
Thank
gonna
you.
I was going to say, wouldn't that be reversal?
Yes,
But that would be a reversal in terms of the court's, the way the court was thinking about it on whatever date the court made this order. I don't have that December
3rd, 2021.
2021. Even if we agreed with you on that point, wouldn't we say, okay, there was insufficient evidence at that point in time, but wouldn't the district court need to undergo some sort of present tense analysis on remand? I mean, what if, for instance, I don't know what the facts are. We don't have them in the record on purpose and by definition in terms of, is your client still sober? Those kinds of questions, if there had hypothetically been a relapse, would the trial court be able to take that into account even if we reversed the original order?
I'll make one more point about reversal and then I'll discuss remand if that's okay. So on the reversal, in this particular instance, he's not the custodial parent and he was already subject to drug testing requirements as a condition of visitation due to the paternity order. So there were protections in place. And unlike a termination, the denial of a petition to terminate rights doesn't foreclose a petition being brought in the future if circumstances change. So here where petitions didn't meet their burden at trial, there wasn't evidence to prove that it was in the best interest and strictly necessary to terminate father's parental rights. The correct remedy would be to remand for reversal or reverse or remand with instructions for reversal. However, if this court does have and may have valid concerns about the continued circumstance, then this court took the approach in NRA AH 2022 UT App 114, paragraph 158, of remanding, but stating that based on the evidence that was presented at trial, it was insufficient to support that father's parental rights should be terminated or that parents' parental rights should be terminated. However, the court could consider if circumstances had materially changed, and unless they had materially changed, this court indicated its anticipation that the district court would deny the petition. So if this court were disinclined to accept our argument, the reversal is the proper remedy, then we would request that the court remand with similar instructions to those given in NRA AH.
Can I ask you a question? It's a little afield from where we are, so if you have more questions there, okay. When we get to the best interest analysis in this case, one of the arguments that you've made is that the grounds were thin, and that because the grounds were thin, that should undermine the analysis as to the best interests. And the response in the other side's brief was, well, the grounds have to be supported by clear and convincing evidence. And so there's something of a sort of philosophical disconnect. It can't be simultaneously true that there's clear and convincing evidence and yet still be thin. And I'm wondering if you could respond to that. How do we navigate that dynamic?
Well, I think maybe a better way of conceptualizing it is this language from BTB, which is this court's 2018 opinion. Statutory grounds can inform the best interest inquiry. The facts supporting the conclusion that statutory grounds for termination are present might also support the conclusion that it is in the child's best interest for the parent's rights to be terminated. And I think that just indicates sort of the logical position that the type of grounds that are at issue, the evidence in support of those grounds, the considerations in play in finding grounds should also come into play in the best interest inquiry. So if we have grounds where a parent is physically or sexually abusive, emotionally abusive, abusing the child's other parent or other children in the home, things like that, those grounds are much stronger. Those grounds involve evidence that much more strongly supports that it wouldn't be in a child's best interest to continue a relationship than the circumstances that we had here, where there was abandonment found, for instance, but father did have lengthy periods of time where he was dealing with addiction and where he was in jail. Sorry.
No, go ahead. I'm waiting for you to pause.
I can pause.
Okay, you're pausing. One of the things that worries me, I take the point, the responsive point. One of the things that worries me as I've thought about that dynamic, though, is this. If we write an opinion that says that as part of the best interest analysis, we are going to sort of dive deeper into the type of grounds and the sort of contextual stuff about the grounds, I wonder if we're going to be creating something of a Pandora's box for ourselves. We're going to complicate the best interest analysis in future cases where we're now going to have 5 or 6 appeals talking about how exactly the interface between those two prongs works. And why wouldn't it just simply be cleaner to say, we have a grounds inquiry, if we get through the grounds inquiry, we get to best interest, and of course in the best interest, we can look at whatever facts matter for best interest, but we're not gonna try to bring the grounds analysis into it, even partially. Why, help me understand why it wouldn't complicate things too much if we do what you're asking us to do.
Okay, if I can give a two-part answer to that, I think that already the holistic nature of the best interest inquiry anticipates that the court will look to all the evidence that was presented, which would include the evidence going to the grounds. So I don't think it's anything wholesale different than the same principle this court recognized in BTB back in 2018, that this is just the evidence going to grounds as part of the evidence that should inform the best interest inquiry. My second part of the answer is if this court is disinclined to want to issue an opinion that could potentially cause confusion on that point. I think that here, even if this court disregarded our argument on that point, that there still is not clear and convincing evidence in support of the termination, clear and convincing evidence proving that termination is in the child's best interest or strictly necessary. So I think that if this court were inclined to think that that's potentially confusing the case law, we should still prevail even if this court disregards that argument completely.
Thank you.
Okay, I don't see any further questions, and there are zeros on the clock, Ms. Johnson, so I think we'll consider the matter submitted at this point. Thank you for coming down and making your argument today. Apologize for the confusion. We will take the matter under advisement and get an opinion out as soon as we're reasonably able to do so. Thank you. Court is adjourned.